The assessment has to recognize that kids should be placed with siblings unless the court finds that it's contrary to the child's best interest. If the QRTP is determined to be necessary by the assessment, the professional must document why the child's needs cannot be met in a family setting. And lack of foster homes isn't a reason. Then this bit about the funding, if the assessment decides that this child doesn't belong in a residential treatment center, then they have 30 days to move them to an eligible placement. Okay.
Beth, can you hear me?
Yes, where are you?
Yes, Shasta.
Hi, Shasta.
There are questions in the chat.
Oh, sorry.
We want to know if it's CYFD who's waiving this requirement, if there's anybody else who can object, like what's the protocol there?
So the law doesn't, of course, drill down to that level of detail, and there's no regs yet. There are a couple of there's one program instruction and a couple of information memoranda. I think they don't outline it either with any much more clarity than what I just said. It is CYFD it's the state agency who would waive, and they waive it by making this statement about objectivity. So they do that in their state plan. And I think that if you had real concerns about the objectivity of the assessment being performed by someone in the department, I think you could argue about it in court, and I would. So I don't think there's a lot of clarity about how you do it. I think you will just have to kind of figure it out as you go and leave it to the judge, because the next thing we're going to talk about is what does the judge need to do. So
they're the ones. This is Georgia. They're supposed to be objective, right? But then they can waive that objectivity?
No, no, sorry if I said that in a funny way. So they're supposed to have an independent person, but they can waive the independent assessor and use somebody in-house if they say that they're objective, if they basically confirm that that person can be objective. So yes, shake your head, make your arguments, because I have doubts about that. I don't actually know, and if anyone's on the Zoom call that knows whether CYFD plans to waive that requirement, I would love to know. I just don't know I don't know what the state has decided.
I do know that I have a couple of cases right now where the PPWs, just certain PPWs, are being very critical of facilities evaluations and how they seem to be diagnosing the kids with way more serious things in order to keep them in the But not all PPWs are being that critical. Some of them are.
Yeah. So we're going to talk a little bit in just 1 second about those kind of issues. So let's just move to that. So this slide is just to send you to where one of these information memoranda is that's about these requirements. But what's it called? The library?
Resource library.
So I'm going to give them the links or the actual documents to put in the resource library related to this. And so you should be able to access everything there after this, after we're done. Okay. So mandatory court review. So the statute requires these court reviews within 60 days of the child being placed in a QRTP. And there is not a tremendous amount of clarity. So I hope what you're getting from this is that the law takes these, as federal statutes do, they write these sort of broad sweeping things without filling in the details. And so the details are still coming. But the state, the court does have to have a review of the placement, and they have to approve or disapprove the placement. And they're looking at these things. Is it the most effective and appropriate level of care? Is the child in the least restrictive environment? Can the child's needs be met in a foster home or somewhere less restrictive? And I would suggest that the court or the attorneys should be asking or arguing whether all community-based treatment options have been exhausted before we go to this level of care. And then, is the placement consistent with the short and long-term goals for the child, which implies and is required that there have to be short and long-term goals for the child, and the treatment that's going to be received by the child has to be linked really clearly to those goals. So if there's not a clear line between the goals established in the plan and by the treatment in the permanency team, then that's probably not the right treatment center for that child, right? So those are really important. What should the court consider in these reviews? So the assessment has to be age appropriate, evidence-based, validated, and a functional assessment. So was it that? I don't even know what one of those things is. I don't know how you find one of those things, and none of the federal guidance provides that information. I think that a follow-up conversation to this one would be with some people from the those accredited agencies about what does one of those assessments look like and how do you know if you have one. And then you want to know if the person who administered it was qualified to administer it, and was there one of these meetings where a family and permanency team participated. We want to know, does the determination that the assessor made, does it follow from what they actually found in their assessment, or did they make some leap of logic when they decided that it was okay to place a child there? And then you want to look at what the documentation was by the person who's approving the placement. Okay, I'm down to 5. Okay. So I just want to say one thing, and maybe we won't do this question, but the mandatory court reviews, the court has to decide whether to approve the placement or not. But the Family First Prevention Services Act is a funding bill. So if the court decides that the placement is not approved, the child doesn't necessarily leave that placement. Placement is in the discretion of the department. So all it means is that the state won't get federal funding. That's a pretty big driver. So probably they'll move the child, but they don't have to. So I just don't want you to think that all of a sudden the kid's going to get yanked. It's not, they're not going to get yanked necessarily. And as I said before, they won't get 4E foster care maintenance payments. They still will get administrative costs. So it's not like it goes to 0. Anyway, I think I'm going to leave this because I want to get to this. Okay, so we're going to switch gears a little bit. And at the beginning, I mentioned that there was this policy change. You can find it in that linked place in the Child Welfare Policy Manual. And what they basically said is that now CYFD can claim admin costs for contract attorneys who are representing candidates for foster care. That's huge. A child who is 4E eligible and who is in foster care, and the kiddo's parents. So what this will cover is preparation for and participation in all stages of foster care related legal proceedings. Whoops, sorry, clicking the wrong thing. So how will it work? So the 4E reimbursement goes to CYFD. That's how 4E works. CYFD is the 4E agency. They will pass the money through, the reimbursement through to AOC through an MOU. That's actually being negotiated now, so we're on our way. AOC will have to document the costs of the attorneys in a format that CYFD can report to the feds. And here's how the money comes back. It's not dollar for dollar. So the reimbursement rate, according to the law, is 50%. It isn't what it sounds like. So I gave an example. So assume New Mexico spends $5 million on court-appointed attorneys in these cases. That amount is multiplied by our New Mexico penetration rate, which is 0.5. That is basically the number of 4E eligible kids in foster care. So you multiply that, and then you multiply that by the reimbursement rate, which is also 0.5. So we would get a reimbursement of $1,250,000 on our $5 million investment. So that's a pretty good amount of money, right? I mean, that's a huge increase. 20, it's almost, I don't know, 20% or so. So what's reimbursable under this new program? Legal representation. So it's about attorneys. It's about their prep and participation in all stages of foster care legal proceedings. In our state, we don't provide pre-filing representation, but because the change in policy allows for candidates for foster care, if we did provide attorneys for pre-filing to do preventative services, preventative lawyering, we could get reimbursed for that. So that's something we really, I think, want to pursue in the future. The policy also makes it super clear that even though the money goes through CYFD, they cannot sort of use their purse strings to limit the time or scope of the legal representation. So they can't influence how you do your work. So there's no conflict of interest, and the MOU has to really lay that out. So what's not reimbursable, unfortunately, are the social workers and parent peer mentors who are involved in the FAP program. So those are not reimbursable costs. However, you can use the reimbursed money to pay for them. So the ways New Mexico is thinking about using these additional funds is these things: Red Book training, child welfare law, specialist certification exam, and annual fees for folks who want to take them. Increased pay for contractors who have that certification. Allowing contract attorneys to bill for time attending training or giving them a stipend to attend training. Incentivizing experts to participate in these cases by offering higher rates of compensation or pay for time consulting with experts. Paying for pre-filing representation. So we're not quite there yet. That's probably going to be like step 2 in New Mexico, but we want to aim for that. We have a lot of questions about how we would do that. Would it be contract attorneys who actually do that work? Would we contract with legal aid? Who would do that preventative lawyering, doing domestic violence work, housing stability work, benefits work, that kind of stuff. And we hope to use it for interdisciplinary representation, so for social workers and parent peer mentors. So I also was thinking about some other options, like maybe we should have advocates, education advocates for children and youth in foster care, or we could fund reduced caseloads, so that would be more attorneys. But what other ideas do you have? What should we do with the reimbursed funds? I will say that both the feds and the state are in agreement that the state being the courts, the child welfare system writ large, so Children's Court Improvement Commission, the courts, the agency, that the additional funds should not be used for things like just giving everybody a raise because we're trying to improve the quality of the whole practice and keep kids out of care. So raises could be part of the whole package, but their raises alone are not going to maximize the impact of this funding. So how else could we do it? Oh my God, really?
No ideas?
What about the ideas we have? Good ideas, bad ideas? Should we keep them, chuck them, do something different? Okay.
Support staff?
Support staff.
Yeah. Yeah.
So that's actually support staff. And what about things like a case management system?
Yes.
I don't know how many of our attorneys actually have an automated case management system.
Huge.
Yeah.
I think
Somebody saying something?
Kristen, I got lots of calls for pre-removal representation back in the day from previous clients who knew about me.
Right. Kristen, yes, I've gotten those as well when I represented somebody before, and now CYFT's back in their lives, and they're worried that their kids are going to get it taken again, and they want that consultation and time. And of course, I mean, I'm sure, Kristen, you're like, you just do it pro bono, but it certainly would be nice if there was a formalized way to actually provide them with representation, so that you could actually like show up at FCMs with them, things like that. Advise them about their options in terms of when they're being asked to either do a power of attorney or a kinship guardianship with a relative, being able to actually advise them about that instead of they're there on their own. Right. Yeah. That would be great. Yes, Shasta?
Well, it's right there on the screen.
Oh, okay. Fax system needs a serious upgrade.
Yeah. So that's in the works, and with a separate whole funding stream from the state. So they got some money in this year's budget, probably not enough to do the whole thing, but they're trying to do it in sort of stepwise. So I think that the whole CWIS fax system that's getting improved. Or
what needs to happen is they need to be able to cross-categorize every single person instead of having here is family number one, and then here's the kid, and then here's the placement. I've had numerous cases where it turns out a family placement had a lot of issues going on, and they were not telling the permanency workers or their placement workers, and investigations was doing this whole other thing, and nobody was talking about it because the families were not actually cross-categorized.
Mm-hmm. Yeah.
Right.
Okay. Other?
Any other thoughts, ideas, questions? Are you
Okay.
at the end of your
I'm
slides?
good.
Okay, so
There's one more person.
got Renee. I think identifying families who might be in need earlier would be
Mhm.
useful.
Yeah.
Yes. I would have loved to have been paid more because it was a child
Yeah.
law specialist. Absolutely, I think I
Totally
agree. The
agree.
incentive to do that should absolutely be there.
And I'll just tell you, so we're working with NAC right now to figure out how to get that Red Book training going, either locally and through online webinars, and possibly through a track at CLI. So we're working out those details now so that all of you who want to be a child welfare law specialist can become one. Of course, you have to pass the test.
And Renee said, for instance, families. So getting, I think the idea is getting involved ahead of being brought into custody. So, for instance, families whose teenagers were in care having babies.
Yes. Yeah. So I think that the statute, the Family First statute, actually is really pretty tuned in to this particular population of teens, pregnant and parenting teens, and really wanting to provide more support services to them. And we didn't really talk about it today, but there is maintained funding for them to stay together and in a family foster care setting, and to provide supports to teens as they age out of the system in whatever fashion they do. And we probably could spend a whole one of these sessions talking just about the pregnant and parenting teens.
But that's another question that I was wondering with this change in funding, because my understanding is that the way that it is now, the parent cannot be in the foster home with the kids, right? So if grandma is the foster parent, or even a non-relative, but if they're the foster parent, that then mom can't, as maybe she's making progress or whatever, just move into that home, or even from the beginning. And that has been one of the things that seemed to me, especially like with real little ones, with babies, and for really young parents, that wouldn't it be great if they could be fostered, right? If the whole family could be fostered, rather than removing the baby and then, having an hour a day maybe with the baby, right? But couldn't they be? And so my question, do you know whether this change in funding might open up that possibility that we could have the parent and child in the foster home?
So meaning like the teen parent?
Or young adult parent, whatever. So if you got 22-year-old mom, right, and with teeny tiny baby, could they both be in the foster home?
I don't think this law says anything about that. So I think what it says is if you are a teen parent and you are in foster care,
right,
and you have a baby, then you and your baby, if that baby was going to be removed from you, you could be placed with your baby in foster care together. But I don't think if the parent is just over 18,
right,
and is the respondent, I don't know that this law says anything about that. What it does say, and if you read between the lines, is they really want as few removals as possible.
Right.
So if you could build an environment, a family foster home setting, where that child doesn't have to be removed from that parent, but you create safety and you provide all those prevention services, then it's not foster care, but it's like pre-removal reasonable efforts.
Right.
So yeah, I think it would support that.
I don't know, in chat, so Kristen posted TFC training for parents when kids come home from TFC. Right. So training for the parents, yes, exactly.
Yeah.
That it looks very clear that that's in there, that kind of funding. And for it was like 6 months or something. I mean,
12
for 12 months. That's
or
awesome.
post. Oh no, sorry, for post like
So
returning
post,
home.
right? That
6 months.
returning home, 6 months.
Right.
And then hosted family homes where parents and their kids live in a home with a coach. That would. So yeah, would this funding cover that? Could we have a coach come in instead of removing kid from the home, have a coach move into the home?
Oh, wouldn't that be slick? Yeah, I don't know. I mean, so my brain went in 2 different directions with that question. One is the first path, which is if we could identify an evidence-based, trauma-informed program that provided coaches in the home, I think that this 4E funding could then be used as a pre-filing prevention service and families could have that. I don't know if we have that. And I don't know if one of those has been approved, but so the state has an opportunity to make suggestions to the feds about programs to study. And so if we know about one of those, we could suggest it to the feds to study. But yes, I think that that's the kind of thing that the feds would be interested in. The other path my brain went on was this new attorney fund reimbursement. Maybe, I mean, what we've stuck with are things that are really about attorneys or legal services, and there's really actually no limitation on that. And you were the one who got me going down this path, Leslie, when you asked me about could we do, I don't even remember what it was now, some very concrete thing like provide transportation costs or something.
Yes.
And I think we could. I think we could use this funding. This reimbursement funding is not, there's no limits in the child welfare policy manual about how to use it. And we'd have to scrutinize the Social Security Act really carefully. I'm sure there are limits on 4E funding to figure out what they are. But if it were for a therapeutic purpose, so for a kid, for a family where a child's returning home to get in-home support, why couldn't we pay for that?
Right.
It's totally to keep the family reunified.
Yes.
So, I mean, I think we could use these funds in way more creative ways. And if you were sitting there as parent attorney, child attorney, GAL, or social worker in any capacity, and you think of things like gaps that, oh my God, if I could just have X for my parent,
right.
Then they'd be successful. That's what these funds should be used for, in my view. So what's the, oh my God, if my parent just had, what's the fill in the blank?
Right. We had a comment from Georgia. She's always told that treatment foster care is a package service and should be enough, but it frequently is not, especially for long-term RTC kids. So Georgia, you're talking about those kids that have been in RTC a long time, then they transition to TFC, step down, and then there's really not kind of the services, and especially, and it looks like this requires to engage the family so that the family's getting training and support as the kid transfers or transitions out of TFC or even to another placement, placement with a relative or something like that from TFC.
Yep.
And then Kristen had an apartment complex for families and kids with an in-house health and mental health office and social worker. Wouldn't that be awesome? I mean, I don't know how many of you know about Saranam. No? So if you don't, look it up. Saranam is an amazing program. I've had probably, I think I've had 3 clients now go through that program successfully. They provide them with housing. They have I don't know that they have clinicians in-house, but they have like case management people in-house. They're required to be in school of some kind. And then they have like all kinds of groups and stuff that they have for them, but they can have their kids there. They can, so yeah, I mean, it's really amazing because they can have the kids placed with them while they're in this program. And I think it's like a 2-year program. It's like a big commitment for the parent, but if they can make it through, it's incredibly helpful and successful. So that's exactly that kind of an idea. Right. We go to 1:15, right?
Oh, okay.
Yeah.
Good.
Okay.
So what's the next
And then
comment?
Georgia, disrupt because they don't have enough in the home and cycle back to RTC. I see it over and over. Yes. Is that
So
it?
that's going back to the idea, Georgia, of having the support in the home when they return. Yeah,
right.
yeah.
Okay. We have any other questions for Beth? Any other thoughts, any other ideas about how you might use some of this in the courtroom to advocate for your parents? Or any of you think of a case that you've had where if you'd been able to make these arguments, it might have made a difference in your case? Have anybody any thoughts about that?
If not, I might go back to the slide I skipped, which was about the hearings.
Okay, should we do that?
We have to figure out how to get there.
Okay, so I think you come down.
You scroll in there and click on it. Okay. There should be a previous.
Okay.
Okay, so tell me which one.
One more.
This mandatory court reviews.
Let me look.
This is for the place, the QRTP.
So I wanted to, I guess what I don't really need the slide. I was just thinking about those mandatory court reviews and what the court has to consider. And actually the court's, really thinking about the court's initial 60-day review of the assessment and when it's approving or disapproving of the placement in the QRTP. And
so I have a question actually about that that occurred to me when you were talking about it. So can this review happen within the neglect abuse case, or are we talking about those mental health reviews that are supposed to be happening and often somehow don't?
That's actually a really good question. I don't think that the feds were thinking of that. I think they're talking about within the abuse or
within
neglect
the
case.
abuse neglect case. Okay.
But I think that's a really good question in our statutory scheme, like how do those two things line up? And so we might need to look at the Children's Code in both the Children's Mental Health Act and the Abuse and Neglect Act about, how do we make those if they're streamlined? But I think the feds were thinking about within the abuse and neglect case, but I don't think they were really clear about what the review means and whether the review is actually a hearing. I mean, what we skipped later was a discussion about how the court has to do ongoing reviews every time there's a status or permanency hearing. But at the initial, so clearly those things are happening in a hearing. But the review of the approval or the assessment, the statute isn't clear about whether that needs to be in a hearing. And so I was just trying to think that through. Like if we didn't have a hearing, what would that mean? I actually think it probably does require a hearing. I think there are due process concerns implicated for the child. I mean, removing them from their home and putting them into a really restrictive environment probably implicates a lot of liberty interests. So I think it probably does necessitate a hearing. But then who has to be at the hearing, and what exactly does the court need to see, and who needs to be present, and do our court rules and forms cover it? I mean, we do have a notice of change of placement, and we have forms that are to inform the parties about the change of placement, whether it's an emergency or a anticipated change of placement. So how do you what's the actual process for that? I was wondering about, and I have heard others on the national scene talk about, does there have to be can this be done on a paper review? And it makes me very nervous to think about doing it on a paper review. But I guess I would be interested in knowing what you all think about that. What's the best way to handle this court approval, disapproval process? Because the feds don't lay one out.
I mean, it certainly seems to me that if you had no matter if you're representing the child or if you're representing the parents, if you have any concerns about the appropriateness of the placement, request a hearing. I feel like it should be heard, right? put the, you know, make them show that all the requirements have been met for continuing this placement in court. That's what I would say. Yeah.
And are there any CCAs on the call? I didn't notice anybody. That's too bad. Because I mean, it's the agency that's going to be placing the child. And I just keep wondering, like, how is the court going to be triggered to do the review if there isn't a request for hearing? So what is the agency going to file if, you know, some request for review? I mean, I just don't know what it would be. So I think we need, you know, I'm sorry, I am the chair of the Children's Court Rules Committee, so my head always goes to the rules and the forms, but do we need a rule or a form about that, or is there a way to do it without that? So, and I know that there are people who have more or less warm feelings about the rules and the forms. So now's your chance to, not your last chance, but your first chance to weigh in about, you know, do we need some mechanism in the rules and forms to trigger it?
So yeah, what's a child welfare director? Who is that person?
I think that's a question. I think the statute means the Secretary of CYFD, but it's possible that it means the Protective Services Director, which at the moment we don't have one. So I would say it's the secretary at the moment in our state.
So I had another question earlier on when you were talking about the obligation of the department to make sure that the assessment is a good one, an appropriate one. And I'm thinking to myself, and who's going to do that?
Right.
I mean, the line social workers, like, among all the other things they're supposed to be doing, number one, and number two, many of them are not licensed social workers. They're, you know, so they don't have the qualifications, the training or the qualifications to make that kind of an assessment. So how is that supposed to happen? I mean, they're going to go out and get a second opinion? I mean, how do they decide that that's really a valid assessment? I mean, I'm thinking about all the times I've argued with the department about an assessment that's done that I have felt over pathologized a child or a parent for that matter. But
Absolutely.
I mean, who makes that decision?
Yeah, so the statute requires this qualified individual to do it. And you know, this is where we were before about, you know, the waiver issue. So the qualified individual has to be independent, barring a waiver. They have to be independent, and they have to not work for one of the placement entities. So that leaves a whole world of people who are out in the field who don't, you know, who have private practice.
Right.
You know, so I mean, I think they'd have to contract with private entities to do those.
Well, but they do that now, and because it's not only private entities, it's private entities who are willing to accept the level of reimbursement that CYFD is going to pay them.
Right.
So then you definitely
narrowed
the pool.
Yeah. Which is why probably they put the waiver in because of limited access to professionals who could do the work. But then I think we have this issue of this objectivity, you know, and what's driving the decision, which is then falls back onto the attorneys to really ask meaningful questions about how are the child's needs determined, and how are they linked to the services that they're advocating for in the placement facility. So really sort of testing all those things and asking about, you know, what's been offered before, what treatments have been offered before, why does this child need treatment, can the treatment be home, you know, provided in a resident, like a home setting with wraparound services, and more basic, the assessment that was done, was it evidence-based, was it age appropriate? I mean, we're going to have to, as a community, we're going to have to do some digging in about what those things are, right? You know, and it's early days, so I don't know, as I told you, what those are. But that might be part two, is figuring out, you know, for kids this age, you know, in this age range, you know, what assessments can they do? And then, I mean, I think we, in our state, probably every state, we need to be asking questions about language. And, you know, what language are these assessments being conducted in? And are they a language that the child actually really understands? You know, and if they're pre-literate, what are we doing about that? You know, so.
I'm also thinking from the parent advocate point of view about whether the parent got input into the assessment, you know, because
Right.
Sometimes they don't even ask the bio parents. They just get all the information from the social worker
Right.
who's known the kid for a month,
Right.
instead of, getting information from the bio family. And then the flip side of that is sort of the message that gets made, when kids are over pathologized, that it makes it harder to reunify, because the argument is, oh, this kid has such a high level of need, these parents can't possibly do it, right? And so really taking it from that direction as well, to foster reunification. Okay, so I think does anybody else have any questions? Because we are about ready, we need to be wrapping up. Are there any other questions, comments that anybody would like to make? No? Okay, so then I would just like to once again remind everybody to please, if you can complete the post-session feedback and reflection form. I think I'm going to ask Jen to put it again in the chat. So if you could please do that for us. A reminder again that we would love to have more, we would love to have some case presentations from our participants, and if you please consider doing that. And then our next ECHO session is June 25th. Our presenter will be Susan Burns. She's a licensed clinical social worker. She's highly credentialed. She's got a lot of experience, and she's going to be talking about recognizing mental health issues, how they manifest throughout the abuse and neglect case process. And that's, in my view, huge. So I am really looking forward to her presentation. Hopefully you can join us. You can encourage others to join us as well. Would really appreciate it. And then finally, thank you so much, Beth. This was wonderful, incredibly informative. Really appreciate it. So, okay. So thanks, everybody.